Let's get started talking about what the tactical steps that you need to take are in order to protect your idea. Step one is always performing what is called a prior art search. So you're going to look into what else is out there. A great place to start is Google Patents. You can use that as a starting point to look up other inventors, other universities that you know are doing research in the space that you're in, specific companies that you know may have products or patents for new products potentially coming down the line. So look them up. And you can also look up product keywords. You can look up other types of problems that other folks in the industry are trying to solve. And you can look into the underlying technology invention as well. Just like Google, you can search for anything you want. You want to keep track of what's coming up and really ask yourself, how is what you're proposing substantially different from what you're coming across? You'll never be able to search for everything, but it's important to at least know what the top of the surface is. And it's important to know what else is out there, at least from a preliminary search. Before you proceed to step two, you need to take an honest look at that prior art and ask yourself, is your idea useful? Is it actually doing something that is usable and provides utility for your customer? Is it novel, especially with respect to other patents or products? And novel just means new. Is it substantially different? And lastly, is it non-obvious? And non-obvious means, could somebody with ordinary skill and knowledge in the field not be able to know this already themselves? So ordinary skill means basically they're not a layperson in the industry, but they have some sort of understanding of the technology, and they would be able to understand and not think that that is obvious. So if you have a yes answer to all three of these, then you might have an invention to protect. So assuming you got the green light to move on to step two, that's going into looking at a provisional patent. You're going to want to get some support from either an IP attorney or your technology transfer office on your campus. You'll work on an application for your provisional patent. The great thing about a provisional patent is that it's fairly short and simple. You don't need to have all of your claims and all of your robust prior art documented in order to submit a provisional patent application. In the United States, there's a law that protects the first to file. So whoever gets that priority date, that first date, that earliest date for protecting the idea, they are the one that gets that patent on that idea. Very important, once you file your provisional patent, you have 12 months to convert it to a non-provisional patent. Otherwise, you lose that priority date. So this, if you're going to be talking about your idea and your invention in any sort of public forum, this is a very important step to take to plant your stake in the ground. One very important thing to think about at this stage as well is who is the inventor and who is the owner of the patent. We'll talk more about that in the last section on working through your university, but it's very important to really be explicit and a little bit conservative on who is an inventor on the technology, because otherwise it can create some problems down the line. Step three, once your provisional patent has been filed, that clock starts ticking, and then you want to get ready to file a non-provisional patent. At that point, you will need to include the very specific claims that detail out exactly how your technology is different from all the other technology and inventions that are out there in that space. Utility patents usually will include the specifications to start. So what is it? Basically, it's a little bit of marketing. What problem does it solve? How does it work? And could someone who has some knowledge of the industry read this specification section and understand how to make and use your product? A patent will usually also have drawings, and it will have those specific claims that I mentioned that are similar to what's in the specifications, but written in a very specific legalese to make sure that you are being very explicit about how you are different than all the other prior art.